Suppose this is Sun. Sun is the central point of focus in our solar system. Around Sun, 9 planets in solar system keeps rotating. Earth rotates around Sun, Mars rotates around Sun, Jupiter, Neptune, Saturn, they keep rotating around the Sun. Similarly, in jurisprudence, every school of thought has one central focal point or a central point of focus, and around that point that theory keeps rotating. In case of sociological jurisprudence, that central point of focus is society. Hey everyone, welcome to Law Simple and Pure. Dr. Vaishali here, and in today's lecture we are going to learn sociological jurisprudence. It is a very easy topic in jurisprudence. In fact, entire jurisprudence is easy. During my last, when I will conduct my last lecture on jurisprudence, I will give you a very simple trick. By using that trick, you can really score well in jurisprudence. By using that trick, you can use your existing knowledge which you have, like a knowledge in constitutional law. You can use the same case laws in jurisprudence, and I will tell you how you are supposed to use those case laws under jurisprudence. By this way, you do not have to study more. Same case laws are required in interpretation of statutes, same case laws are required in constitutional law of India, and same case laws you can use in jurisprudence. You can provide lots of case laws and score really good. Before going ahead, I want to tell you one very important thing. I'm providing more videos on LLM, like LLM lectures I'm going to take. Lectures which are important for JMFC and UPSC, so they are coming up. So please like and subscribe, and please help me with the topic list so that I can give justice to your needs in my next lecture. So let us begin with sociological jurisprudence. 5 important points involved in this school of thought. Number 1, society is a central point of all legal development. Number 2, law is made for society. Number 3, whether that law serves society is a test for testing that law, whether it is good law or bad law. Next thing, sociological jurists disagree with command theory. People do not follow law because of command. People follow it because it is needed by society. And last thing is, society is a central point of all legal realities. Because why law is there? Because society needs it. Why law is there? Because there is a social problem. So that is the central point. For example, why do we have Child Marriage Restraint Act in India? Because child marriage is a social problem in India, and that's why law comes there. So law is there to solve social problem. So these are the main points about this school of jurisprudence. Various philosophers or jurists are involved in this school. They are sociologists, and then they provided their opinion about law. So it's an interdisciplinary type of approach. It is traceable back to David Hume, according to whom law owes its origin to social conventions and is itself a developing social institution. So law has its origin in society, and it is itself a social institution. Then Montesquieu is there. Montesquieu put forward the idea that law originated out of social custom, and good laws therefore had to be in accordance with the spirit of society. So law comes from social customs, because social customs, why they are followed by society? Because society is comfortable with those customs. So this is Montesquieu's opinion. Then Auguste Comte, according to him, law is a tool to maintain society. Why society needs law? Because there are social problems, and then law comes there to solve those social problems. So this is an opinion of Montesquieu. After that, 4 main philosophers come. Eyring. According to Eyring, law is there to control and regulate society, but Eyring means role of coercion. Coercion means force. So according to him, while doing that social control, coercion matters. Force used by law matters to control the society. So Eyring means coercion. Next philosopher, Emile Durkheim, social solidarity. Solidarity means people staying together. That integrated type of thing is solidarity. So Emile Durkheim put forth this. He was a French sociologist. So, and according to him, role of law is to keep social solidarity in society, to maintain a homogeneity in that society. So law was the standard by which any society could be evaluated, since law reproduces the principal form of social solidarity. So why law is there? To control the society and keep the society together. So Eyring means coercion. Emil Durkheim means social solidarity. Next philosopher, Eldridge, center is society. So according to Eldridge, law is inner order of human association. The center of legal development lies in society, not in legislation. So according to him, legislative law is not important. Law which is made for society, which comes from society like custom, that is more important. So according to him, judicial decisions and legislative law is secondary. Law which comes from society is primary. Eldridge divided solidarity in two types: mechanical solidarity and organic solidarity. Mechanical solidarity is found in a homogeneous type of society, means all the people are similar or equal type of people, and in that society more and more crimes are there, and that's why function of law is more type of repressive and punishments are more. And in case of heterogeneous society in which different people come together, they achieve organic society, organic solidarity, and function of law is not suppressive but it is restitutive, means just maintaining the status quo. Most important philosopher in this school is Roscoe Pound. Roscoe Pound emphasized on interdisciplinary approach of law. According to him, law comes from society, law is a part of social science, and hence you cannot separate law from society and study it. Afterwards, he provided 8 points which are important while considering any law. Number 1, a factual study of social effect of legal administration. So, effect of legal administration on society must be studied. Number 2, social investigations preliminary to legislation. So, before making any law, social investigation is necessary. Example, before making law on polygamy, social investigation was made. And what social investigation? Yes, polygamy existed in Indian society, and that's why law against polygamy was made. So social investigations which are preliminary to legislation. So before making any law, some investigations into society are needed. Number 3, a constant study of means for making laws more and more effective. So keep studying the law and make it more and more effective. Next, the study both psychological and philosophical aspect of law. It means philosophy of law as well as psychological effect of that law on society must be studied. Next, sociological study of legal history. So study of legal history but from societal point of view must be done. Next, allowances for the possibility of a just and reasonable solution of individual cases. Instead of applying one solution to all the cases, it should be studied on its benefit and individualistic solution must be provided. Next, a Ministry of Justice should be provided. And last, the achievement of the purpose of various laws must be studied, whether this law is successful or not. Example, in India, Child Marriage Act is not completely successful. It is successful to a certain extent. Prohibition of sati, now it is 100% successful, right? Female Foeticide Act, it is again not 100% successful. It still happens in India. So that study must be made. So these are the 8 points which are provided by Roscoe Pound, and after that comes his famous theory of social engineering. What is a function of an engineer? Okay, suppose a car is going and that car stops working. What will an engineer do? He will go there, he will do necessary repairing, he will put some oil in that car if required, and he will start the car. Now the friction in the machine is avoided and car starts running smoothly. Same function law will do for society. So law is an engineer for society, because in society different people, they have different interests, right? And then because of that, those different interests, people fight with each other. And what is the function of law? To avoid that friction, to avoid that fight, so that society runs smoothly. So law will act as an engineer in case of social problems. There are different types of interest, like individual interest, like right to property. And then there are social interest. Social interest means entire society is interested in that. For example, state wants to construct a dam, okay? For that dam, property of a certain person is required. So here, that person's right to property is getting violated. But it is done for a social good, and that's why it is allowed. So there is a clash between individual interest and public interest, and that clash must be avoided. Individual interest means fundamental rights, and public interest or social interest means directive principles. So when there is a clash between these two types of interest, law should intervene and law should decide which interest prevails over which interest. So that is all about sociological jurisprudence. Please stay tuned. During last lecture, I'm going to provide you very simple tricks by which you can score really well in jurisprudence, because jurisprudence is not at all difficult. So stay tuned till my next lecture. Goodbye and good luck.